Welcome to Friday Morning Conference, the first Monday day of first quarter Friday. It's my pleasure to introduce our esteemed speakers today. I want to tell you after, when you have questions, that we will bring you a microphone, so don't just stand up and yell it. We are honored today to have Peter Stokstad and Lisa Hausbeck, who are with the Health Law Division of Garlington Law Robinson. Peter has been here since 1996. He has been involved with a couple hundred malpractice suits, works with the Montana Medical Association and the legal panel. I think we can stipulate his qualifications. And Lisa is a somewhat new member of the team, but she also does malpractice and health and things like HIPAA and medical licensure issues.
Make sure I'm on. Can you hear me? Well, good morning. Thank you very much for allowing us to come. I know I speak on behalf of our law firm that we really appreciate the opportunity to assist healthcare providers both here in Missoula and throughout the state of Montana. It's also a little more personal for Liz and I. Liz's father was a practicing urologist. I think he's retired now for many years in South Carolina. And her brother Will is a urologist at the Huntsman Cancer Institute in Salt Lake City. So there's definitely a personal dimension to what we do. We're not just a couple of lawyers who are defending healthcare practitioners. I grew up around the table with two nurses. My mother was a medical surgical nurse for about 40 years in Seattle with Swedish Hospital. And then my sister is currently a certified oncology nurse at the Seattle Cancer Care Alliance. So I've spent many dinners around the table hearing about issues in hospitals and with doctors and nurse-patient ratios and all of those things. So doing this is more than just a job for us. We do care about healthcare providers and want to make sure that if there's anything we can do to assist you, that's something we're available to do. So we have a fairly short amount of time. We plan on presenting for about 45 minutes and then hopefully leaving the rest of the time for questions. We are going to focus on what we've called hot button issues in medical malpractice. You can imagine we could talk about a lot of different areas and spend a great deal of time on particular areas, but we're going to just talk about, I think, 3 or 4 areas. First, we're going to talk a little bit about the electronic medical record, and we'll probably spend a bit of time on that. And then we're going to spend a little bit of time talking about the sort of prickly topic of physicians that maybe are observing a colleague who maybe is not acting ethically or practicing within the standard of care, and sort of how you handle it from the perspective of how do you go about reporting that if you do to a licensing authority, and then this issue of what I would call a subsequent treater who's offering criticism of who we would call the defendant doctor. And obviously these are prickly situations, and we want to talk a little bit about that. We'll talk a little bit about just busy medical practice and what that means for medical malpractice claims, and then we'll end with a little bit of a discussion about the law, some of the new law, one law in particular that came out of the legislature this year. So that'll be what we talk about in the next 45 minutes. But I wanted to start by sort of reaffirming a couple of things. Our firm, I think we've defended about 1,600 malpractice claims, and make sure I'm doing all of this correctly. Your best insurance against a malpractice claim is not insurance that you buy if you're a healthcare provider. There's really 2 things that are just fundamental to avoiding or minimizing the risk of a malpractice claim, and that is good bedside manner and good documentation. And I know this is not something that's new to you. An American philosophy once said it's not so much that we need to be instructed as we need to be reminded of things. And so when we look back at the cases that we've defended, and you kind of peel back the onion, these are the two things that jump out as issues in the case. And when we talk about bedside manner, we're not talking about some sort of unscientific feel-good thing. It's a very real issue for patients. And when I talk about it this morning for a few minutes, it's beyond just bedside manner in the sense of the doctor-patient relationship or the nurse or allied healthcare provider-patient relationship. It's a larger issue of effective communication within the healthcare system. So these are really the two best insurance you have against a malpractice claim. The practice of learning about communication, I was looking through the Joint Commission Sentinel event statistics. I think they go back to about 2004 up to the present. And as you know, Sentinel events are these unanticipated bad outcomes that occur in a healthcare setting where the patient either dies or has serious injury. Unanticipated and not related to their, the natural course of their illness. And it was interesting to see, and the Sentinel events have under them, there are particular root causes or really core causes for what occurred. And in all of these different categories, breakdown in communication was either at the top of the list or was right among the most, predominant root cause for a Sentinel event. Between the doctor and the patient, nurse patient, and healthcare provider and patient, and the larger healthcare system. Listening to doctors, I don't know how many of you have read much of Malcolm Gladwell's work. I mean, I have glasses for this. I thought I was going to be able to do this without my glasses, but when I was read much of Malcolm Gladwell, I found him to be extremely interesting in his books and the way he kind of looks at the world. And he wrote a book called Blink, The Power of Thinking Without Thinking. And in one of the chapters is entitled Listening to Doctors. And he summarizes some studies that people have done about effective communication in the healthcare setting. And he says here, and I'm going to just quote a little bit from the chapter, he says, patients file lawsuits because they've been harmed by shoddy medical care and something else happens to them. What is that something else? It's how they were treated on a personal level by their doctor. What comes up again and again in malpractice cases is that patients say they were rushed or ignored or treated poorly. Gladwell goes on to sort of summarize some of these studies, and he goes on to say, when a patient has a bad medical result, the doctor has to take time to explain what happened and to answer the patient's questions, to treat him like a human being. The doctors who don't are the ones who get sued. He then references one of these studies. It says, recently the medical researcher William Levinson recorded hundreds of conversations between a group of physicians and their patients. And he goes on to summarize what the findings were. He says roughly half of the doctors had never been sued. The other half had been sued at least twice. And Levinson found that just on the basis of those conversations, she could find clear differences between the two groups. And so he goes on to summarize what it was about the doctors who got sued and how they communicated versus the physicians who had not been sued. And he concludes, he says, the difference was entirely in how they talked to their patients. He finally ends the chapter by saying, malpractice sounds like one of those infinitely complicated and multidimensional problems, but in the end it comes down to a matter of respect, and the simplest way that respect is communicated is through tone of voice. And the most corrosive tone of voice that a doctor can assume is a dominant tone. And I thought that was interesting, and it just, again, highlights, I guess my point is to highlight how important effective communication is, because you as healthcare providers have an expertise. Obviously, there's a lot you have to offer your patients in terms of important clinical diagnostic information, but oftentimes it's not so much what you say to the patient, but how you say it that really matters. And I see that even in my own practice. How you communicate is really critically important. The other thing I would say about that too is I think the other flip side of that is listening. and how important being a good listener is. And as we talk about busy healthcare practices, I wonder about listening and how effective we are, and that includes myself in my law practice. The busier I get, I wonder how effective I am at listening, because that's really important. I was reading, I don't know if you've read Atul Gawan's book, Being Mortal, but he talks about, it's a book about sort of end-of-life decisions and how you have those discussions with people. And I was really touched by, he was pretty vulnerable as a surgeon to talk about how he learned to listen to patients, to really figure out what do they need and what do they want. And so again, my only point this morning is to underscore that when we look at these malpractice claims that we've defended, effective bedside manner and communication is one of the most important things you can take away from this. This was a study from the American, I didn't cite it unfortunately, but it's a study from the American Medical Association. It's a little bit old, but they did a study. They interviewed patients, and I think they interviewed hundreds of them. And they concluded, and these were patients who presented to clinics, hospitals, and so it wasn't just limited to physicians, it was kind of the healthcare community. But they concluded that providers who are sued the most were rude, rushing, and failed to answer questions, and the providers who are sued the least are concerned, accessible, and willing to communicate. So that's bedside manner. The next is documentation. Your lawsuit, if you, God forbid, ever find yourself in a medical malpractice lawsuit, your documentation or your defense of the claim will only be as good as your documentation. Now this morning we're going to talk about the electronic medical record, and a question that may arise in your mind as well is documentation as important now that we have the electronic record as opposed to the older paper charts? I would say it's more important, and the principle of good documentation is still extremely important whether you're dealing with a paper chart or an electronic medical record. And so good documentation. How bad charting can hurt you in a malpractice setting? You have to remember that you may find yourself in a lawsuit 3, 5, 6 years after the care is provided. And so you're going to be called upon to remember details, interactions you had with the patient, decisions that you made with regard to the care of the patient some years after the care was provided. And I can tell you I've been to several hundred medical malpractice panels, and I've had both nurses and doctors listen to the patient tell their story, and they look at me with their jaw dropping, saying, I don't remember this, this is not how it went down. And then I'm saying, well, where is it in the chart? And if they don't have good documentation, they're left to their memory to try to remember details that occurred years after the care was provided. And so good documentation will protect you in that way. Patients have really clear memories, but what's interesting is that the studies show that their recall is very poor of the actual interactions. And so they have a very convincing story to tell, but the story may be very inaccurate because patient recall, through the studies that we've read, indicate that patient recall is very poor. It may be their only interaction with the healthcare system, and so they come in, and again, they tell a very convincing story. In the meantime, you may have seen hundreds or thousands of patients between the time of the original care that's the subject of a lawsuit and the time that you're sitting either in a deposition or at a panel hearing or in court, God forbid. So documentation is really critically important, and it's really, really important today with regard to the electronic medical record. We had a case, this is just a quick example, we had a case involving, he was a young man, 35 years old. He saw a family practice doctor for what appeared to be some shoulder pain. He reported by history that he was lifting some boxes. The doctor had some suspicions because the level of pain he had was not really meshing with the history that was provided. So the doctor, had a discussion with him. It was late on a Friday afternoon. He said, I think you should probably go see an orthopedic surgeon. And the young man said, I don't really want to do that. I don't have time. And thankfully, after that note, it was late on Friday. The doctor could have packed up and gone home, but he documented his discussion with the patient. The patient ended up not going and seeing an orthopedic surgeon. He ended up with some fairly serious right shoulder issues. And when we got the medical records, it turned out in the lawsuit that he had suffered before, unbeknownst to him, I think, that he had suffered a seizure which resulted in posterior bilateral dislocations of his shoulder. And so when we went to the panel, the young man was very convincing. He said, that doctor never told me that I should go see an orthopedic surgeon. And the panel, he had the panel eating out of his hand. He was a very persuasive young man. But we were able to put up the records to show that at the time of the care, the doctor documented this very carefully, and we were able to show that the recall of the patient was really inaccurate. So again, I can't underscore how important good documentation is. I'm going to talk now, we're going to move into talking about probably the first sort of hot button topic, and that is the electronic medical record. And, again, I would say just by way of introducing this topic that Liz and I are not experts in this area, that the clients that we have throughout the state have different EMR systems. And so what we're going to share is not specific to a particular electronic healthcare record, but it's just things that we've observed. And then Liz is going to talk a little bit about some of the data that one of the insurance companies we work with have put together in terms of the kinds of claims they're seeing in the setting of the electronic medical record. But I wanted to start by at least acknowledging, I think the goal of EMR is that there are some advantages. For example, I've just listed, these are just our thoughts about it, but I think the goal was decreased documentation time. I know I've heard from clients who have had different feelings about that as they were kind of getting up to speed on it. There's probably some generational things. I think as younger providers come in, the electronic record's probably something that's a little bit easier for them to navigate than those of us that are getting a little bit older. Increased legibility and accuracy, clear, decisive, concise words, alerts, alerting the provider if the patient has an improper drug interaction. I mean, you guys know all of this. There are just things about it that are very helpful. Statistical analysis of data is enhanced implementation of the nursing process, enhanced decision-making, multidisciplinary networking, assuming you've got EMRs that are talking to each other, because we've seen that. My assistant at my office worked for a hospital system in California that had 20 different EMR systems. None of them communicated with each other. And she talked about how difficult that was in her work. And then trigger physician follow-up. There's triggers within. So there's things that are very helpful. What I'm going to talk about a little bit now is what we've seen in the context of medical malpractice claims. So what we did is Liz and I sat down and we went through the list of our current cases that we're defending right now for healthcare providers. And this is just a sampling of some of the kinds of issues that we're seeing in the cases that we're defending. So the first one is what I would call hybrid systems. We're defending a hospital where the claim is made that there was a delay in diagnosing breast cancer in a patient. And when we first got the case, as we always had done, we asked the medical records department of the hospital to provide us with all the medical records for this patient. We wanted a complete listing. We wanted every record they had, so they provided it to us. And then within probably a couple of months, the attorney for the plaintiff was saying, well, when she came in for her mammogram, she filled out a patient questionnaire, like a mammography history questionnaire that had a writing. She signed it. It provided history of what her problem was. And that was not, when we got the records, unbeknownst to us, we didn't see that in the electronic medical record that was provided to us. Well, we learned later that the mammography tech would scan the actual document into their PACS system. So we didn't get the documents out of the PACS system. Now that may not sound like a big deal, but when we got the document, there were some changes made to the document according to the patient. She said that there were some alterations made to it. So you combine that with the fact that this document kind of was not available for a couple of months. When we went to the panel hearing, the attorney was implying that this document, that the hospital was hiding the document. And so it was an issue in the case. It's not necessarily a central issue, but it's a part of the case, and it's part of, I think, this was an example where this hospital had both part of their system was paper and part of their system was EMR. The second case, time stamping, we have a case where a gentleman underwent surgery, and 2 days later, he ended up dying on the floor of the hospital. And there was no autopsy done, so it's unclear what the cause of death was. But in the deposition of one of the hospital nurses, he coded in the late afternoon, and early in the afternoon, the nurse testified that she contacted the doctor because there were some clinical signs and there were some changes clinically that prompted the nurse to contact the physician. But she got busy, and then when she went into the electronic chart, she did it sometime later. So the timestamp for when she actually entered the note that she contacted the doctor was closer in time to the time of the code. So it made it, the plaintiffs again are, they spin cases. If you don't know, that's their job when they're suing you guys. They spin. So the whole spin on this is that the time entry for her call to the doctor was really close in time to the time of the code, and the implications that the nurse waited too long to talk to the doctor about these clinical changes. So that's an example where the EMR is playing a role in the case. Hospitals transition to EMR. In the same breast cancer case, one of the issues in the case has to do with whether the patient, when she came to the hospital, arrived unscheduled for what they call a screening mammogram, which is a less invasive, it's not as focused an exam as a diagnostic, as I'm sure you all know. She is arguing and claiming that she was actually scheduled for a particular date to have her right breast examined, to have a diagnostic mammogram. Well, when she came in in April of 2011. The hospital transitioned to their new EMR in May of 2011, and their scheduling program in the old system they've not been able to locate. So we're not able to prove or disprove whether this visit was an unscheduled screening mammogram or whether it was a scheduled diagnostic mammogram, which is important to the case. Next is EMR causing provider to focus on computer, not patient. I put that in there. This is more out of my personal experience. I recently had it's been 6 years since I had a physical examination of a great doctor here in Missoula, but it was just interesting to sit down because we did spend quite a bit of time looking at the computer as we were going through my visit. And it was a great visit. He's a great doc, no issues for me, but it just made me wonder about this issue of how we listen and how we're interacting with patients and kind of on the ground here in a room with a patient where you're not really paying attention. Could be interpreted that way. So, and I'm sure you guys have talked about this. You guys are way ahead of the curve. I mean, these EMR issues have been implemented some years ago, and we're just seeing these now in these lawsuits. So, but I just thought it was an interesting experience, personal experience of kind of being with a physician who was really looking at the screen. And again, for me, it wasn't a big deal, but maybe for another patient, it might be more important for them to feel like the attention's being paid to them. Drop-down menu. I've had some cases where providers have told me that they're given some choices for diagnoses that don't necessarily fit with what was going on, and just some frustration with that. Locking of note. We're currently defending a GI case where the physician did a very nice job of going through the consent, documenting consent with the patient. She was an elderly patient, so obviously there are increased risks of subjecting an elderly patient to a colonoscopy. She did end up perforating 3 weeks later after their visit, but the note was excellent. It was just very detailed. He really spent time with the patient, helping her understand what her risks were. The problem was that the note was signed 5 months after so it was electronically signed 5 months after the actual visit, pre-procedure visit. So what we've had to do is, and that's next on the list, is use the audit trail. And we're seeing a lot of that. Plaintiffs' counsel are routinely now asking for the hospital's audit trail because they want to find out when you actually access the record, because the audit trail will tell exactly when you access the record. And fortunately, in this GI case, we got the audit trail, and it's clear that the doctor didn't go back in, as the plaintiffs are implying, and kind of make his note more bulletproof, so to speak, because the audit trail shows that he only went in on that one day, and he documented his note and his consent that day, and that he was asked as a part of a computer, an EMR upgrade, to go back and lock a bunch of notes that he just hadn't well. He uses the word locked or electronically signed. Narrative feature. I put that in there just because I know that there are EMRs that have that feature, and we really believe that that's an important part. If you have a patient or something's unusual about a patient or the situation, it's really hard. I got to be honest. In the old days with the paper chart, we would go to the nurse's notes and we'd have kind of a story. We'd know what was going on with the patient, and the EMR is just a little less inviting that way. It's just because of these. There's a lot of drop down, and there's a lot. And Liz will talk about some of the other issues, but the narrative can really be helpful if you have a situation where the patient, there's something unusual. And so I guess what I'm urging is the use of the narrative part of that EMR if you need to do that. And then the last thing before Liz gets up is paper versus EMR display issues. Again, not a huge issue, but in several cases, and one in particular right now, we had a deposition of a nurse in a case, and when she was presented with her records, she said, immediately, she goes, I don't recognize this because the paper version of the record is different than what she sees on the screen when she's actually at work, working the EMR. And so, it wasn't an insurmountable issue, but it can be, and it's just something that we've run into. So these are just a few examples of things that we're currently dealing with where the EMR is maybe a contributing factor to the case. It's not the center of the case necessarily, but it's being used by plaintiffs to buttress their cases. So with that, I'm going to pass it over to Liz, who's going to give you a little bit more information about some data on that issue.
Thanks, Peter. So as Peter mentioned, in the legal world, we're quite a few years behind the rest of you. And so we're just now seeing studies that are taking this data and saying, what claims are arising that are related to the EMR. And we were only able to find one published study that one insurance company did, and it took claims from 2007 to the middle of 2014 and determine which of those claims were somehow related to the EMR. And I will tell you that in 2007, I think they had 2 claims, and then just the first half of 2014, it was 22 claims. And so the claims that we're seeing are definitely continuing to rise. The plaintiff's bar is having seminars that are solely focused on how to attack EMRs in lawsuits. In fact, in one court, not in Montana, but in one court, the plaintiff's attorney was successful in excluding the entire electronic medical record from the case on the grounds that it contained too much duplicative, irrelevant information, and also that it had so many errors in it that it just could not be reliable. So hopefully this isn't a trend we start to see, because it's a little bit hard to defend care without the EMR, especially as Peter mentioned, when you've seen 1 million patients and you're defending this case that the care may have arisen 3 years ago. So the one study that this insurance company had from 2007 through the middle of 2014, there were approximately 100 EMR-related claims. Notably, that was only about 1% of their total claims, but as I said, it's continuing to rise. Of those claims, approximately 40% of them were related to some sort of system design, so some sort of failure with the EMR itself. The other 60% of them were related to user errors, so something that the user did to cause the claims. So the common pitfalls, and what I'll talk about here is some of the examples from the studies, as well as some of the experiences that Peter and I are seeing now in our current cases. So copy and paste, auto-filling, auto-populating. This is one of the biggest ones that we see, and I have gender confusion and typos. It seems like a minor issue. It's not going to cause a lawsuit, but I will tell you that when we get the records and there's a lawsuit for another reason, how it hurts the provider is if you consistently are referring to the male patient as a female, if there are lots of typos, the plaintiff's attorneys will make a mountain out of a molehill and use that to just show that you're not thoughtful, you're not careful, you're not paying attention. They will use these little details to imply that your care was careless. And so that's where we see it all the time, just very minor things, misuse of pronouns. Failure to update pertinent information. This one can cause more problems. One example, I believe this one was from the study, the medical record said the catheter will be removed tomorrow. That information copied and pasted for the patient's entire post-operative course, and what was missing is whether the catheter was ever removed. And other examples with failure to update pertinent information and the copy and paste feature. We have a case right now where we're defending an orthopedic surgeon, and one of the issues in the case is whether the patient's post-operative course, whether he was experiencing more pain than would typically be expected following the procedure. And it was undisputed that our physician was prescribing him pain medication, that he was taking pain meds. However, for each of the post-operative notes, the same information was copied and pasted, which said the patient is taking no pain medications. Again, this is not central to the case, but it's just one of those things that the plaintiff's attorney is pointing to just say, you can't rely on this medical record. You can't trust what this provider's saying, even though the provider is extremely confident and very thoughtful. So that's an example of where we're seeing it. Another example is we have another breast cancer case. Primary care provider sees the patient. She is complaining of a breast lump and breast tenderness. Our primary care provider appropriately documents that information, appropriately orders a diagnostic bilateral mammogram, does all the right things. But then if you scroll down in the EMR to the actual physical exam, when it comes to breast, it says no lump, no tenderness. So again, I mean, it's undisputed that she had a lump and she had tenderness, but it's just one of those things that just shows that the EMR may not be that reliable, or at least the plaintiffs can argue that. The one case that was cited from the study, which resulted in I believe, a multi-million-dollar settlement, a toddler presented, he had been out of the country to an area where tuberculosis was present, and comes back from the trip and he has fever, rash, and is fussy. Well, the physician copied and pasted from a previous office visit, no TB exposure. 2 weeks later, toddler lands in the emergency department, is diagnosed with tuberculosis, meningitis, suffered severe cognitive impairments. So that's an example of where it's not just making the provider look sloppy, but actually is causing great harm. Alert issues. So one of the issues we hear is just a couple things about the alerts. Number one, you just get too many of them to maybe give each alert the attention that it deserves. And number two is that you're getting so many alerts that it's actually deterring from patient care. You're trying to see your patient, you're constantly dealing with these alerts. It interrupts your train of thought and thus deflects from patient care. Drug alerts, the example there from the study, and this could be viewed as both a system failure and a user failure. This elderly female presented with nose and ear complaints. The doctor went to prescribe Flonase, types FLO into the electronic record, and the system auto-matched Flomax, which is used for an enlarged prostate, and wasn't called, no drug alert, and it caused the female some issues. Insufficient area to document drop-down menus. Peter hit on that briefly. One complaint that we've heard, which has hopefully been resolved at this point, is that if you hover over some of the drop-down menus for too long, it'll automatically just throw in a diagnosis or other information. Hopefully that's been resolved, because for obvious reasons that can cause some problems. The other thing with the narrative section, and again, hopefully that's another thing that's been resolved, is that some EMRs force the provider basically to chart by exception, only diagnose or only chart the abnormalities, and then all of a sudden everything else gets auto-populated. And it makes it appear that the physician actually did more than he actually did, because lungs normal, vitals normal, all of that, when maybe that wasn't part of the exam. And so with this auto-populating, it just really, it makes the medical record not have an authentic feel to it. And it could leave people thinking, was anything done at all? Was the provider even there? And so what the narrative can do, even with just a few sentences that individualizes the patient and the medical record, is it makes the whole rest of the record appear authentic. And so, again, that's just something that we can't emphasize enough, the importance of utilizing that area. So as Peter mentioned, we're certainly not experts with the EMR, but this is just what our experience has been. It does appear that a lot of these issues that are both arguably user and system errors are being fixed. For example, I know that some EMRs with the copy and paste feature, because it can obviously be used for good reason, to save time, to get some of the pertinent information carried over into the chart. And so what some of the EMRs are now doing is, if you copy and paste, it'll highlight that information in the new record, and then a nurse or the provider has to click on what you pasted, just basically to verify that it's all still accurate. So hopefully with time, these systems can continue to improve, and we'll see less claims and be able to account for those. So now, jumping to a different topic that we often get questions about. We get phone calls from time to time from providers asking about their obligation to report what they believe is care that falls below the applicable standard of care. So we get phone calls saying, I think that colleague so-and-so, he has committed malpractice. Do I have a mandatory obligation to report to the board? Obviously, this is an incredibly delicate issue, and in addressing the decision, there are two really important considerations. And the first is the mandatory duty to report unprofessional conduct to the Board of Medical Examiners, but then balancing that with the ethical obligations to colleagues about talking about a colleague to a patient or a third party regarding the colleague's care. So first, let's look at the statutory duty. So Montana law says that any physician shall report conduct that appears to show that the physician is medically incompetent, mentally or physically impaired, or guilty of unprofessional conduct. And then the law goes on to define all the different things that constitute unprofessional conduct. And one of them is conduct that does not meet the generally accepted standards of care. So the argument there is that if you know or have reason to suspect that there's conduct that falls below the applicable standard of care, that you have a mandatory duty to report. However, we caution providers all the time that when making this consideration, to make sure that you have absolutely all of the facts. Because as we have here, studies that have been done show that over 50% of claims are generated because of comments that one provider makes when criticizing another. We see it all the time. We'll depose the plaintiffs, and the plaintiff will say, you'll ask a question like, why did you think my doctor did something wrong? And they say, I was told by subsequent provider X that mistakes were made, that shouldn't have been done. You shouldn't have been treated that way. So just little comments that maybe set off the cuff that turn into lawsuits and create these lawsuits. And so what we advise providers is that before you make any sort of a critical comment, before you say anything that can be interpreted as such, just to make sure you have all the facts. And to do that, listen to the patient's version of the story, but as you listen to it, realize it may not be completely accurate. Number two, make sure you have all the relevant medical records. Just as if you were going to serve as an expert for a case, get all past medical records, anything that can be relevant to make sure that you're seeing the entire picture. And then the third thing, which is maybe the most important of all, is before you criticize another provider, call that provider, get their side of the story. Because as we all know, not everything can be contained in the medical records, and the provider may say something that absolutely can change your mind about the care that was provided. And so our advice is, yes, there's this mandatory obligation to report, but make sure that you do your due diligence to ensure that it is care that falls below the standard of care. And this actually goes right along with the ethics manual of the American College of Physicians. It is unethical for a physician to disparage the professional competence, knowledge, qualifications, or service of another physician to a patient or third party without substantial evidence. So again, it's an incredibly delicate decision, and it definitely generates claims, but you do have to balance that with your ethical obligations. And we would recommend that before you do it, in addition to doing your due diligence, also talk to a trusted colleague, the risk manager at your hospital, just to make sure that you're not missing anything and having a very objective view of the care. With that, I'm going to hand it back over to Peter.
Thanks, Liz. I've got just a couple of minutes. I was going to underscore a couple of things. You know, we're talking about the medical record, and it's really important for you to know that the record is really an expression of your expertness and your competence. And so when we take these cases to trial or to a hearing, that's what juries are looking for. They're looking for providers who have that competence, that expertness, and that caring and that compassion that goes with being an effective healthcare provider. And so your medical record is really an expression of that. And so with all of these issues that we've just talked about, that can really, they may not, like Liz said, be the central issue in the malpractice case. There may be a more central issue related to the actual malpractice, but it really provides the backdrop and flavor. And if the documentation isn't really strong and good and complete and accurate, it's really an expression of your competence, and juries will question it. So I just wanted to underscore that. In the last couple of minutes, we were asked to talk a little bit about kind of other hot button topics, and I'm going to just take a real quick minute. You can see I don't have a lot of information about being distracted or being too busy. I know that in my practice, you know, we all get busy, and being too busy, you will run the risk of a lawsuit. You'll run the risk of a claim, and only you know if you're getting too busy. I don't have any sage wisdom to provide you about that. I just know that when I'm busy, and I've been very busy in the last kind of 6 months just with various cases, there are things that kind of drop to the wayside, and I know one of them is, you know, how attentive I am to my clients, how strong am I in my communication with them. Am I really listening, or am I in such a hurry because I'm seeing so many patients every day that I'm thinking, you make assumptions about I'm going to go down one diagnostic pathway when in fact the patient may be saying something different or maybe providing information to you that might cause you to consider another diagnosis, those kinds of things. So the upshot of all this is I don't have any real wisdom to impart other than if you know you're too busy, there needs to be a change that you should consider making. And I know that it's a complicated question because it's beyond necessarily just your own personal, there's systems issues and how many patients you're seeing every day. I will just end by saying that we do see a number of cases where providers, because they were too busy, things got missed, and that's why we saw a lawsuit. The last thing we'll talk about, and I'll just do this really quickly, is the legislature met this year and they changed the laws with regard to the statute of limitations in medical malpractice cases. It used to be 3 years and now it's only 2. And then also they changed and you can read it there, you can see the 2 years after the date of injury. And then there's a service rule. It used to be that once a plaintiff filed, they actually walked to the courthouse and filed a complaint at the court, they had 3 years in which to actually serve the provider, to actually, in essence, to get the lawsuit started. So the statute has been changed to 6 months. We think that's a great thing. You know, we talked about you being in a deposition 6 years after the care is rendered. You know, this is going to shorten those times, and I think that can only be a positive thing. So we're at about 45 minutes, and so with that, we thank you. There are a lot of issues we could have covered, but given our time constraints, we tried to focus on just a few hot button issues. So if there's any questions, we're here to answer them.
Oh, wait, can we go back?
Oh, yeah.
Using the microphone.
Unhitch myself first.
Fine, thanks. If you could just go back to the prior slides, just to let you know.
Yes.
So towards the bottom, when kids being actually commenced after 5 years from the date, how does that really change the prior statutes? You said they had moved it up. Once they commenced, but it looks like it can run up to 5 years anyway.
So the general rule is that it was 3 years from the date that the malpractice occurred, and now it's down to 2. And then I think this has to do with the discovery of the malpractice. So there are cases where the patient may not have known that malpractice occurred, and at some point later they discover it. So the statute of limitations would actually be longer than just the 3 years. I don't know if that makes sense. So it's a discovery, so it has to do with the discovery. A patient may not know that the malpractice occurred on year 1 and may a year later have maybe talked to another provider and learned of the malpractice. The courts have said that then the statute, the clock starts to tick at that point. But it can be no longer than 5 years is the outside. Does that make sense?
It's nebulous, but I guess it makes sense.
Okay.
How about extended?
What's that?
How about extended to people discovering bad babies in 7 or 8 years?
I think it has to do, I didn't put it up there, I'd have to look at the statute, I don't have it in front of me, but I know that we kind of cut it off, but I know that the statute, it extends the deadline in the setting of infants. I don't remember the precise deadlines.
I have another question
Yes.
while I have the microphone. Now that primary care physicians are not providing hospital care, are you seeing cases revolving around information not being transmitted or patients' wishes not being fulfilled or
Transmitted in what context?
any problems you see with hospitalists who don't take care of the patient the rest of the time?
You know, we have several cases where, I have 2 surgery cases where the question in my mind is, because the patient had surgery, so there's the surgeon involved, there may be consultants who are brought in, and then there's a hospitalist, and the question that the jury always asks is who's quarterbacking the situation? You know, there's a bad outcome, the patient gets septic, for example, who was in charge? So we see those kinds of cases. I will tell you that in the context of family practice, there's still, I think in the most recent statistics I've seen, they're the number 1. The number of claims are still family practice, internal medicine, and OB/GYN are the top 3 specialties that are getting sued.
Do you see cases where hospitalists initiate, or ER docs for that matter, initiate extensive care on people who had filed do not necessitate orders with their primary care physicians?
Say that again.
We all see a primary care physician
Right.
who allegedly knows us and knows what we want and what our family wants. But when the patient actually shows up at the hospital, that information often doesn't get transmitted, at least immediately. And patients get resuscitated, they get put on intubation, all kinds of things. Do you see lawsuits around that?
We have one right now where the patient was at one hospital. There was clear instructions that she wasn't a DNR. She then got transferred to a smaller hospital. That information was not transferred, and somehow a DNR was placed on the chart. She ended up having a high potassium. The day that she died was critically high potassium. She ended up dying, and part of the issue in the claim was that was enough effort made to resuscitate her. I mean, DNR applies when the patient stops breathing, their heart stops, but there was a mistake made in terms of her being placed as a DNR on the chart because that information from the previous hospital was not transmitted to the other hospital. So I don't know if that answers your question. Yeah. Any other questions? Well, thank you very much. We appreciate being able to